The open rebellion that was raised as an issue relating to naira redesign policy. First, let me start by way of linking the naira redesign policy to the ownership spirit associated with election. I tried to explain in the course of my submission that some of the provisions introduced into the Electoral Act were intended to ensure that Nigerians take effective ownership of their election process by way of ensuring that no foreign funds are allowed to influence our decision in terms of ownership, and by way of limiting the idea of, the contributions by Nigerians to the political parties. So if you are to consider extending it further, perhaps a situation whereby naira redesign is factored into our electoral process consideration, it could equally have the possibility of ensuring that money is not allowed to play a prominent role in affecting the freedom of judgment of Nigerians. So it is about a policy, and a policy is intended, one, generally with particular reference to naira redesign. The intention is to, I talked to you equally about Money Laundering Act, which is intended to bring about the greater visibility and transparency in what we do in financial sense. So the policy associated with the naira redesign has a lot of advantages. Advantages associated with the fight against corruption in terms of bringing about the desired visibility and transparency. Advantages associated with sustenance and allowing the freedom of judgment of Nigerians to prevail. Freedom devoid of monetary inducement and interventions is equally part of it. But then, on the issue relating to the open rebellion, as you characterize it, one, I would like to comment more in view of the fact that the sizable portion of such considerations constitute a subject matter of litigation before the Supreme Court. But above all, as you rightly know, you equally raise issue of treason or perhaps certain undertones associated with it. These issues are usually issues that are issues of process. So you cannot rule out the possibility of investigation, but the responsibility of investigation and doing the needful arising from the weight and assessment of the implications of the statements and utterances is the responsibility of security agencies, and I believe they are doing the needful in that respect to determine whether there is need for further action. Actions associated with investigations, actions associated with prosecution, and what other measures needs to be taken in case it is their conclusion that there is need for actions to be taken relating to the utterances made. So that is the best I can say in that respect relating to open rebellion. Now, the last question, I think, it was about deficiency of prosecution, notwithstanding the robust laws that are in place. Well, the idea of prosecution, honestly, is something that you need to understand that is a function of, first, perhaps maybe a complaint, 2, investigation, 3, gathering evidence and profiling same for presentation before judicial process. So it's not a kind of, it's a process that is indeed loaded with a lot of component of consideration, other components relating to the executive, the judiciary, among others. But the true position of things is, as a system, we have been doing the needful in terms of prosecuting people that are presented, that are indeed where there exists a prima facie allegation of commission of electoral offenses in view of the fact that the laws are there. And out of desire to further enhance the quality and the reach associated with prosecution, the Office of the Attorney General has generated a fiat investing the powers in the state attorneys general to prosecute offenders in their localities. So notwithstanding having in place the laws, we equally consider the possibility of a collaborative approach by which the powers of the Attorney General of the Federation are donated to the state attorneys, all out of desire to ensure at the end of the day that regardless of how remote and where the offense is committed, something is done in that direction. We have a collective responsibility to ensure that this democracy works, and then arising from that realization, we are doing the needful. But I have told you earlier, over time, what we have tried to do is to be fine-tuning our legislative framework. So if, for example, the need has arisen perhaps to have to have tribunals or things of that nature, there are things that one cannot rule out the possibility of considering. But the truths of the matter is we are doing the needful, we will keep improving, we keep working until we get to the promised land in terms of having a perfect election. But I believe, and certainly so, that you will agree with me, what we had in 1999, what we had in 2003, 2007, 11, and 15 is certainly different from what we have in terms of the quality of our electioneering processes. So we have been evolving, we will keep revolving, and we will keep attaining. Thank you very much.